and thank you for your patience for item E, which is a work session on and possible action on Order 14-02-11-07. We have Alex Schuyler, Intergovernmental Relations Manager, and momentarily I will ask Mr. Farnsworth and Mr. Osmond to step to the table. Mr. Schuyler. One moment, please.
Okay. Thank you, Mr. Chair and members of the Commission. I'm Alex Schuyler, your Intergovernmental Relations Manager, here today on a resolution regarding, among other things, the National Defense Authorization Act. Clearly, testimony this morning shows the interest in this. This is, I think, the third time now that you've had folks in to talk to you about language in the 2012 National Defense Authorization Act. I did prepare a board order and resolution for your examination today. The process here is that normally this kind of thing, and it was the case today, goes to County Council prior to coming to you for consideration. There's been a lot of discussion about various parts of the 2012 NDAA specifically, and whether they are constitutional or not. I really took a cue from last year when there were sheriffs in Oregon who were starting to talk about not abiding by whatever law would be passed by Congress. There was sort of an expectation after the Newtown shooting that there would be additional gun control legislation being presented in Washington, D.C. There was an expression sort of prior even to that action from some sheriffs across the U.S. that they would not agree to uphold any laws that Congress passed with respect to those kinds of laws. And our sheriff, in response to that, suggested that he'd taken this oath of office when he took office and would abide by whatever laws that Congress passed. And it just made me think about the actions that you've been requested to take today or otherwise with respect to passing a resolution expressing your concern for what are suggested to be unconstitutional provisions of law that have been passed by this act, the NDAA, which is an annual appropriations bill passed by Congress. I tried to lay out the story here where how laws do get changed in the United States, either through the United States Congress, actions of both chambers and a signature by the President, or by the Supreme Court finding that a law is indeed unconstitutional. Those are the two methods available to us as United States citizens for having laws changed. And you, as a board, have taken up your concern with the language in the 2012 NDAA, both as individuals. In your packet, there's a letter from last year from Commissioner Sorensen, and again late last year with a letter from the board as a whole, reaching out to in particular our senators as they were about to vote on the 2014 NDAA and expressing your concern. I would note that, and I did note in the board order that in fact the two senators from Oregon were the only two Democrats in the United States Congress to vote against the 2014 NDAA. Now, I checked with their offices after that vote to find out if our correspondence to them had any bearing on their vote in opposition to the bill, and what I was told was that it did not, that they had had other concerns with the measure and voted against it for those reasons. But even in 2012, I've gotten some correspondence from Senator Merkley's office where he did vote in 2012 against the 2012 NDAA due to the provisions that were found in the bill as it came to the Senate. And so it's definitely a sort of ongoing story about the provisions from 2012, and you've heard a lot of testimony about it today. There's the resolution that I authored here does conclude that you would reaffirm your concern over that particular language and continue to express your concern about it. Frankly, you have the ability to reach out to your Oregon senators. They've already voted against this bill. There may be some more advocacy we can do with respect to it. I'm not exactly sure what that would look like in terms of trying to get other senators to express their concern over these provisions. Perhaps a more strongly worded order or resolution that could be used by a national advocacy organization against this could be useful. That's certainly within your purview to take another stab at writing something that you'd like to have more specific with respect to that language. But I'm frankly, I'm just not quite sure what more we can do, what you can do, than continue to write to the Oregon delegation to express your concern with the measure. There's been sort of this conversation about, well, you could in fact suggest that you won't enforce those, or you would direct the sheriff to not enforce certain provisions, which is fine. I think it sort of sets the board up for a conversation about civil disobedience, if you will, and how far you want to take that. If we're willing to step into that milieu as a county, where should it end? Clearly, we've been advocating for changes in federal forest policy for the better part of the last 15 years. And is it time now to stop that advocacy and go into the federal forest and start cutting trees without the United States Forest Service or the Bureau of Land Management's authority? I mean, I think these are sort of the questions that you really have to ask yourself is, do you as a Board of Commissioners get to pick and choose which laws you'd like to enforce, abide by, or otherwise? And that's why I crafted the ordinance, or excuse me, the order/resolution as it exists today, to simply point out that you will continue to work to change this, but the vehicle available for your advocacy is fairly limited.
Thank you, Mr. Kyler. Any questions or comments for Mr. Kyler from the board? Commissioner Sorensen.
I'm wondering, because of the public interest in this, if we could maybe step back from this and look at a range of what other governments have passed as resolutions. Not that we want to do it the way all the others have done it, but if there are some examples out there, and then maybe we could have different options in front of us of what we could do. I just Googled the phrase City of Albany, New York, NDAA, and came up, the first item is Albany, New York introduces strongest resolution in America against NDAA. So, that, I don't know a whole lot about what their resolution was, but that would be an example of moving this forward. We could have several options for the public to comment on, so we could build on the idea of here's a National Defense Authorization Act that says we're all for it, and we don't think there are any problems or constitutional intrusions, and we think it's great that the military can lock up the public. So that would be one, and that would be like option A. And then there might be this Albany, New York one, option B, and then we would open this up to public comment so we could get a sense from public of, well, how far do they want us to go. My own view is that having a strong sense of the board that we've considered, things like the spying, which I think is a separate topic. I could be wrong on that, but I think that the main topic is the incarceration provision, which I think is what the district court, in ruling it unconstitutional, really focused on. And I think several people in the public comment talked about, the experience of Japanese Americans in World War II and having them incarcerated by U.S. military. The irony is that if you've gone to any of these places, which I've gone to the one in Idaho, and I've gone to the memorial for this in Washington, D.C., that actually Japanese American men were actually barred from serving in the U.S. Army at the beginning of this incarceration period. But toward the end, when there was greater trust in the fact that these Japanese Americans were actually loyal U.S. citizens, they actually allowed Japanese Americans men to join the U.S. Army, and they were actually sent to the European theater so that when they came home to visit their families, they actually had to go to these internment camps to visit their families wearing their U.S. Army uniforms. I mean, it's a pretty incredible story for those of us that are too young to have seen it. So I don't think it's as far-fetched as some people might say, that, oh, you're just worrying about something that won't occur, when we know that in the case of someone that's my age, my parents actually saw this. So, and we're not talking about something as distant as, genocide in Germany or genocide in Cambodia. We're talking about things that occurred right here. So one idea is to have an array of these resolutions so that we can schedule a public hearing, hear from the public, that the public comment will be meaningful. I think that it's one thing to say that we're going to tell Congress that we think their provisions of this law are unconstitutional, and we agree with the federal court that ruled it unconstitutional, and we think Congress ought to repeal it and ought to cut off any litigation over this by simply getting the Congress to repeal it. That's one process. It's another to say that there's going to be some sort of, we're not going to follow the law. As I understand it, the National Defense Authorization Act section that allows the federal military to take Oregon citizens or U.S. citizens into custody, it doesn't require the state of Oregon or the Lane County Sheriff to assist in that process. It's almost like the immigration and naturalization process, where at least in Oregon, it has been the law that Oregon state troopers were not allowed to participate in enforcement activities of the border patrol, for example. So I'm not sure that there is a state component in this, but there may be.
Commissioner Farr.
Thank you, Commissioner Sorensen. Ms. Schuyler.
May I respond?
Please.
Commissioner Sorensen, there's a wide range of resolutions one could write, and we've seen a number of those. You've received numerous emails asking for various componentry of such a resolution. Was discussed, look at the Oath Keepers website. There's a draft resolution there. There are that organization in particular is suggesting that people do not obey any sort of orders to arrest or otherwise detain United States citizens. And that's my concern, is that I think you can write whatever you'd like. Our process is we do send these things through council to make sure they're okay, and so I just don't, I think there would be some pushback at some point, depending on how far you want to go. Looking at the draft resolution on the Oath Keepers website, I mean, they're essentially trying and convicting the President of the United States for the language in this law and want you to resolve to that, or want a body to resolve to that. And so I think there are some elements here that we have to be consider quite closely, just what sort of statements do you want to put into an order of the Board of County Commissioners. So, like I said, I tried and I tried to come up with something that would indicate you're hearing this issue and your expression of continuing to work on it in the methods that you have available to you. Is there something that could be worded stronger than this and make it through County Council to be okay? Probably there is. Would it be as strong as some of the things that I've seen emailed to you in the last couple of days? I'd be surprised if you could get a resolution or an order like that through County Council saying that that would be in line with your oaths as elected officials.
Yeah, my question was about other cities or counties, so that we could take out the extremes of those cities and counties, but at least we would have cities and counties resolutions to look at.
And Chairman Farr and Commissioner Sorensen, I did look at some of those ordinances. I did not specifically review the one from Albany, New York.
Thank you, Mr. Kiley. Thank you, Commissioner Sorensen. Commissioner Lycan?
Thank you, Mr. Chair. Alex, first of all, on putting forth a resolution, is this resolution, and maybe it's more appropriate for County Council also to be involved, but I'll just ask your opinion as well. If Lane County were to put out a resolution, and the language is fairly significant, fairly strong, is it binding when it comes to upholding federal law? So how is Lane County going to incorporate, I guess my question really comes down to, it's a piece of paper. What authority do we have when it comes to a action by the U.S. government? And one of the things I remember going through the exercise with the immigration issue a few years ago, and we'd get templates, email templates, and from folks all over the country. I probably got 300 with 20 coming here locally. And I think what people didn't understand is that Oregon state law, there's Oregon state law, there's federal law, there's state law as well. So, and that cities and counties did not have authority on federal immigration policy whatsoever. It was there. I suggest they contacted the state legislators, because they had passed a law originally when the federal law came in '87, and upheld it again in the early 200s, 2000, I'm not sure when. But so it comes back to, if we were to put forth a resolution, it had teeth in it, for lack of a better word. What does it do? I mean, what does it truly do, and what can the county do, and what can't the county do? Because this is federal law, but what is it that, other than the fact we passed a resolution and folks felt good about it, and I go back to my experience in the Holocaust. I got a Holocaust museum. I go back to that because to me that was pretty darn profound. People did not think that there was an issue here, and they turned a blind eye. And I keep thinking, if local government would have maybe stepped in a little bit more, could there have been a change there? I don't know. I'm not going to right history, but it seems to be that could have been an issue there. So, as we are here today, in your opinion, and again, this is what it's going to come down to, passing a resolution, what does it actually do?
Chairman
Sorry
Farr,
about the
Commissioner
broad
Lycan.
question.
You know, my experience is the feds trump the state and the state trumps the locals, and that's typically how it works. I will say that one of the things that I thought about as an interesting sort of allegory here is that, you know, even today in Salem, there's a lot of discussion about state marijuana policy. Clearly, the federal government does not allow for the distribution of that, I think it's a Class A drug. Yet states to the north of us and to the east of us have passed laws that allow for stores to sell it to average citizens. So I think I get your question. I think it does come down to the sense of the board. What you commissioners, you can write whatever you'd like to do and you can pass it. One of the things that personally I felt was, what sort of jeopardy does authoring something that essentially could be construed as breaking the law have on an individual employee? If you suggest through an order that the employees of Lane County should not follow this language because your opinion is that it's not constitutional, what sort of jeopardy do you place employees in? That's a question that I personally experienced as I was trying to write something that I thought at least followed the laws as I understand them with respect to changing law.
That's a quick follow-up, Mr. Chair. Would you have a recommendation then, because while we have an order, I guess we do have an order, so we have a possible action. But I have heard clearly from my colleagues they're interested in a public hearing. So I'm probably suggesting, and I don't want to put words in my colleague's mouth, we're probably not going to take action on this today, but maybe the action would be a public hearing. I got to tell you, based on the back and forth here, it'd be kind of interesting to hear from those we have respect for as far as constitutional attorneys are concerned. Commissioner Sorensen, heard him earlier, I think from his after the public comment period, about this is going through the courts. Sounds like one court has taken it up, but I'm assuming that's a district court. I have no idea, and so it'd be interesting if it went through as high as the Court of Appeals, eventually to the Supreme Court, because it sounds like to me that some of these issues here, and then I think we just saw this, we have this other press release called Fight Back, and it's something Representative Sensenbrenner and Senator Leahy have proposed the U.S. Freedom Act, which will force the Obama administration to rein in its illegal surveillance practices and bring some measure of public oversight to government surveillance. And by the way, it does bring interesting bedfellows, because the fact that you have Senator Wyden and Senator Paul on the same side on this one as well. So you never know. So I think it does make sense having a public hearing just to kind of hear from folks. I'd be interested to hear from some of the constitutional attorneys on what their thought is, especially as a local government's perspective. That's really what I'd like to get my arms around a little bit more before we go through and take action, and also maybe get a little bit more from the court's perspective. And I think it would make sense maybe to hear from folks from Senator Wyden and Senator Merkley's office and Congressman DeFazio's office, who really are kind of more involved in this, if they could also bring forth some of the information from their perspective on the federal side on where we go from the local government. But it's a good discussion to have, and I do appreciate it being brought forth by the folks. I think it's important to have this discussion, but it's also coming down to, is the paper worth just the cost just a sheet you paid for in the store? I don't know, and those are some questions I'd like to have answered as well as we go through this process. But I think a public hearing is warranted. Thank you, Mr. Chair.
Thank you, Commissioner Lycan. Commissioner Stewart, and then I will ask further questions for Mr. Kyler, and then I'll ask Mr. Farnsworth and Mr. Osmond to step to the table for questions that the board may have for you. Commissioner Stewart.
Thank you, Mr. Chair. Thanks, Mr. Kyler. I guess there was one comment that I wanted to tease out just a little bit more. You talked about the fact, do we move to the point of civil disobedience in the timber conversation, and I don't know if it's fair to compare something that's not the same issue constitutional wise. I mean, yes, the ONC Act or provisions are a law that's been passed, but it's not in our Constitution. And so I'm wondering if, in your mind, should we be trying to have a conversation based on the merits of its level of importance, as far as what it has physically incorporated into it with the Constitution or basic rights?
Commissioner Farr, Commissioner Stewart, I'm not sure I can answer that question. I brought up that example. I brought up the marijuana example, which is another, I think, good example of, sort of a formal form of civil disobedience. There are states have passed laws that are saying to the federal government, I don't know what they're saying. They're saying, bring it on. We're absolutely violating a federal law by passing this language.
And I guess
this language was passed in a bill in Congress. You've got to believe that there were attorneys in the United States Congress who penned it, and so they thought it was okay. It did go in front of a federal court in Manhattan that found it unconstitutional. It was subsequently overturned by the United States Circuit Court of Appeals about 6 months later. So it doesn't appear to be making its way through that path. Commissioner Lycan brought up another act that is, I haven't seen that one in particular, but I'm assuming that it would do things to change this kind of language. And all I'm suggesting is that, at least my experience, our normal course of action is we either say we like bills that are going through Congress or we don't like bills that are going through Congress. We don't typically order that we violate the laws of the land in pursuit of expressing our disapproval of those laws.
Right.
Thank you, Mr. Keller.
And just to expand a little bit, as I look at this issue, and I've stated before at previous meetings, is that we're in a period of time right now when there's a lot of concern. It's just like the presentation of the NSA piece that we see, and all the different things going on in this country and around the world. And then it even brings it home to here, where we've struggled, and I've struggled personally with code that appears to read one way, and then in the end game, it's actually something else. And trying to, I think, be respectful to our citizens and even ourselves. That I believe it's important that it's clear. As our attorney looked through those provisions, they said, well, here at this point it says this, and then you go down here to other provisions, and it says that if you're a United States citizen, it doesn't apply. Well, once again, that's really confusing, to try to put it mildly, as to how's that going to be enacted. And I find right now, standing up with our voice for the citizens and making it clear that we're very concerned with the language, that it needs to be clear and concise and exact as to what it is, and in our minds it doesn't conflict with the Constitution. And as I ponder and ask, what does the county commissioners do? Well, we don't arrest people physically. That's the job of the sheriff. It's also not my job to tell the sheriff what to do. It's the citizens of this county who elect them to do that. We can make suggestions and we can say things, but it's just like talking to legal counsel this morning. If we find or come to our knowledge that the sheriff has arrested somebody under, taken jurisdiction of somebody, and under this act, under this provision, it would be the board's ability to say, well, Sheriff, we believe that you're detaining this person and not giving their constitutional rights, so therefore we're not going to indemnify you for your actions. You stand on your own. That could be the level of what would physically take place with this board. But as the citizens spoke this morning, it's really a rising up of trying to build critical mass to show how important it is to the state, and the state shows how important it is to the federal government. I think that's really the total concern here, and standing there with them, with my own personal experiences of, being clear and concise in a world today when it's so easy for people to take things out of context and make them fit their personal agendas, I guess, no matter what level you are or who you are, and bringing some assurances to the citizens that this is the clear language, this is what I expect.
And Commissioner Stewart, I think that's what I tried to do with the board order, is that the final resolution of the board order is that you express your concern over that language and you affirm your willingness to continue to work on it. Ultimately, I think the board order we're in agreement that this is not appropriate language. There's certainly been a voice of concern by the citizens. You're going to continue to work on it, and that's what the board order, at least in my read of it, suggests, that you've got a process. I mean, we could do something in Salem with respect to trying to gain a voice up there. There's nothing in the short session that addresses this. The next opportunity obviously would be January of 2015, and essentially the tool available to you there is a joint, is some sort of house or joint memorial, which is essentially a letter to Congress. We've done one of those in the past. They're an exercise to go through in Salem. And certainly you've got the tools to direct staff to do that.
Thank you, Ms. Carler. I'm hearing certain support for a work session regarding this, and not actually taking action on the order today. That being the case, I would anticipate during agenda items we'll ask for a work session regarding this. And Mr. Osborne, Mr. Farnsworth, you'll have plenty of opportunity during the work session. During the public hearing is what's being called for, and in the interim to get your information to us further. You also have a packet you'd like to submit today, I do believe. At this point, with the board's indulgence, I will ask Mr. Farnsworth and Mr. Osborne to come forward for questions only. We do have more items on the agenda before we recess at noon. So I'm going to ask you to step forward for a response to questions. There'll not be much opportunity for actual dialogue at this session. That will come subsequent to this. Once again, this is extraordinary. This is not something that we would normally do, but please step forward to the table. And at this point, questions for Mr. Farnsworth or for Mr. Osborne from the board. And if there are no questions, then it'll just be a nice little exercise in you stepping to the table and stepping back. So
sure. Good to be here.
Commissioner Sorensen.
Well, while we were talking about all this, I did look at that City of Albany resolution, and I see that among other things, they said the City of Albany is not a battlefield with its residents and visitors subject to detention under the law of war. And they said that the Common Council of the City of Albany strongly reaffirmed their loyalty to the rights and liberties enshrined within the Constitution, including the Fifth Amendment right to due process. They recognized that the City of Albany is not a battlefield. They requested that their congressional representatives, and they named their senators and their U.S. representative. They named the president. They named the Attorney General of the state of New York and the Governor of New York, and they request a resolution be transmitted to all those folks. They also requested congressional representatives monitor the implementation of sections 1021 and 1022. And they said the City of Albany the City of Albany expected all federal and state law enforcement officials acting within the City of Albany to work in accordance with the Constitution of the United States. My question is, what do you think about this resolution? Do you like it? Are there better ones that other governments have passed?
Albany is one of the better ones with the most teeth, as was said earlier. And so we do like that one. We might want to add a few other things that they don't add in this one, but the battlefield and what you mentioned, it is a strong resolution. So.
And and I'd just like to point out the language in the resolution really kind of makes a statement, but at the same time it doesn't. And when you look, it says expect all federal and state law enforcement officials working with the county. You're pretty much you're making a statement there that they will be working with accordance with local law and state law. So I mean, you're just expecting them to do so. You're not threatening or requiring or interposing against them. And also they bring up to instruct all their agencies to decline requests by the federal agencies acting under the detention powers or similar law authority that could infringe upon the residents' freedom of speech, religion, assembly, privacy, or right to counsel. And that's really good language. And I actually talked to my national coordinator last night about this resolution, and he gave me an email to one of the councilmen, and so I could provide that to you guys, and you might be able to converse with them. What he told me, my national director told me, is the councilmen will say it's really not binding at all. Like Sid, you kind of mentioned, what really does it do besides really make a strong statement. So, yeah, we think this is really good. We have two resolutions we actually endorse. This resolution and our RCG, which we never introduced our RCG in here.
What's RCG?
Restoring constitutional governance.
Oh, okay.
I think we originally, when I met with you, I had that resolution, but we think this one words things a little better. And in fact, the RCG is a little bit more radical, which has been passed too in other counties and cities.
And one thing to add to that, I was hoping that, as looking at this as a guideline, I know that Lane County is special in the fact that we have something called County Home Rule that does give you guys a little bit more authority and sovereignty over some would say some of the other counties in the state. And it says here from ORS 203035, Section 3, governing body of electors of the county may, by ordinance, exercise authority within the county over matters of county concern to the full extent allowed by the constitutions and the laws of the United States and of the state. And so I would say that, under our Constitution and the federal Constitution of due process, that it would be in your authority to enact an ordinance even that says that, here in Lane County, it would be against the law to enforce this. And as so many people have come to you stating that is our request of the people, and that is our view of our interpretive rights under the Constitution, that the county sheriff should then also enforce that. Now, I know you can't force him to do that, but if this is an ordinance written, it seems like if he's taking an oath to protect the laws of this county and of the state, then he should be, abiding by his oath.
Thank you, Mr. Farnsworth. Commissioner Lycan. Thank you.
Thank you, Mr. Chair. Real quick question, and by the way, Oregon as a whole is a home rule state, so cities have home rule as well, counties have home rule, and that's pretty common here within the state of Oregon. The question I have, though, is the Constitution of the United States is, I'm not a constitutional scholar, but I clearly took my U.S. history classes very sincere, and but the Constitution of the United States is very broadly written. You have 26 amendments. Oregon has hundreds because it's much more strictly written. So my question is, as you're coming before the Lane County Board of Commissioners, have you looked at maybe pursuing more much more aggressive action with the courts. It seems to me that also part of this, your strategy should, if you want to come to local governments for resolutions, it seems to me they're going to the courts as well, having, and especially the federal court system. Maybe it starts at the district court. I would like to see something like this, at least at the very bare minimum, get up to a court of appeals. I think that that's where you could, because it seems to me that, and I'm not an expert in this by any stretch of the imagination, but clearly it seems to me there needs to be some codifying done within 1021 and 1022. So my question, have you pursued going through the courts, or is your strategy really going through local and coming through resolutions?
Well, at the national level, it was Christopher Hedges versus the Obama administration, and that went to the federal district court, Southern District Court in New York, where the court ruled it was a violation of the First, the Fifth, and the 14th Amendment. It later went to the Second District Court of Appeals, where they didn't Circuit Court of Appeals, thank you, and they didn't actually rule in the constitutionality of the NDA itself. What they said is that the plaintiffs didn't have standing, so they avoided the whole discussion altogether. And so, to this point, when it went to the federal judge, they ruled it unconstitutional. It was the Second Circuit Court of Appeals that said, they took that ruling back simply because of a technicality. So our approach at the state levels is to approach county sheriffs, which is the highest elected official in the county for executive branch. We're coming to the county commissioners, who are the highest elected officials of the legislative branch for our county purposes. And if you look at the Supreme Court case Prince versus the United States, where Richard Sheriff Mack and Mr. Prince came, who are both county sheriffs, they were actually ruled in favor when they sued the administration for the Clinton administration for forcing them to comply with federal laws, and they actually won in the Supreme Court under that case. And I have here in Scalia's opinion, it says his opinion states that the framers designed the Constitution to allow federal regulation and regulation of international and interstate matters, but not internal matters reserved to the state legislatures. The majority arrives at the conclusion that allowing the federal government to draft the police officers of the 50 states into a service would increase the power far beyond what the Constitution intends. And so what those county sheriffs were doing up in Lynn County, standing up against gun laws, even though whatever you think about gun laws, it was their duty to not have to just blindly follow, such as Thomas Turner is doing right now, anything that comes down to from the Congress or the Supreme Court, is that you have to, as a county sheriff, it's your obligation to say, well, you're the final checks and balance. Is that really a law constitutional? And up in Lynn County, he decided not to. So we're coming down.
Thank you.
Yeah.
Thank you. I would like to state also on behalf of Tom Turner, I've never seen him blindly follow anything.
That's good. Thank you.
Further questions? Then thank you very much, and we will discuss this during agenda committee requests. Thank you very much.
Mr. Chair.
Agenda committee requests. Thank you very much.
Mr. Chair.
Commissioner Sorensen.
Yeah, I'm just wondering, in planning this next phase, whether the idea that we would get some of these other resolutions so we see tangibly what because other people, like those 9 city councilors in Albany, New York, they probably had a lot of the same concerns we did about how do we reconcile the elected district attorney or elected sheriff with the common council of the city of Albany, New York, or the Lane County Board of Commissioners. And it seems like that'd be we wouldn't have to reinvent the wheel also. And then the advocates that want us to make it as strong as possible, they can bring in some of those other ones that we heard mention of, and that can be something they could testify on. And we could also invite the law enforcement community, the district attorney, the sheriff, maybe the police chiefs of some of the larger cities that would have the time maybe to do this, is to give them an opportunity to give their perspective, because there is a nexus between the work of law enforcement and this law. Is there any news? Maybe I can ask Alex, at the point that we have the hearing, perhaps you could find out what the latest is on whether this case is going to go further up to the Supreme Court or not. You know, that's just nothing that I'm asking you today, but
Thank you.
just to be informed, because it is going up the ladder in the system.
Thank you very much, and thank you, Commissioner Swanson, for your high interest in this. It is of sufficient import that we take further time to discuss this. Thank you very much.
Appreciate it. Thank you.
Please, if you would leave that with the administrator, that'll be passed along to us. A question before we move on to item F on the agenda. We have a need for executive session prior to the noon recess. Is that correct? We have, is